Welcome back. Should Connecticut follow Rhode Island's lead and implement trucks-only tolling? Republicans say no because the state might also follow Rhode Island's lead in being sued by the trucking industry.
Yeah, the American Trucking Association is claiming that a trucks-only toll system violates the Commerce Clause of the U.S. Constitution. And recently, a federal appeals court cleared the way for the case to move forward. Should Connecticut lawmakers now think twice before approving trucks-only tolls here? We're going to talk about this now with a frequent contributor on legal matters. Quinnipiac University professor Bill Dunlap is here, and I want to ask him about the impeachment drama too. But first, trucks and tolls.
Welcome.
How will this case go?
Much.
The Commerce Clause has been used in a lot of ways over the years to find something unconstitutional or constitutional, I suppose. But how does this play in with the trucks, the Commerce Clause? What is it?
Well, it's very hard to know how the Rhode Island case is going to come out. When the First Circuit Court of Appeals last week allowed the lawsuit from the trucking industry to go forward, it was simply saying, making a very technical statement, this case is available for a lawsuit. It was not making any statement one way or the other on the constitutionality of the Rhode Island tolls. What that case said last week was the tolls are not a tax. And the state had persuaded the trial court to dismiss the case because challenges to state taxes have to start in state court as a general rule rather than federal court. So all this case said is this is not a tax, it's a toll. So they allowed the case to go forward, and now it's like starting all over again.
Can it go forward on both trails? The state court have simultaneous actions going on in state court and federal?
No, at the moment it'll just go on in federal court, and then it'll probably never reach state court because from the trial court where it is now, it'll go to the Court of Appeals again to the United States Supreme Court, and then that will pretty much be the end of the constitutional issue.
So the ruling last week just really bumps it back to the first court that made the decision, and that is a federal court.
Exactly right. And now that federal court is going to have to decide whether what's frequently referred to as the dormant commerce power of the Constitution prohibits the state from issuing toll or from collecting tolls in that particular way. What Rhode Island is trying to do, apparently, and a number of politicians have said this fairly explicitly, is shift the cost of repairing and maintaining Rhode Island's interstate highways onto out-of-staters. They clearly cannot do that. That would be per se unconstitutional to say only interstate traffic has to pay tolls. But what they've done is focused on tractor-trailer trucks. And I would guess that 95% or more of the tractor-trailer trucks on Rhode Island highways are interstate trucks. So the trucking industry is saying they are virtually singling out interstate traffic to pay the cost of Rhode Island's highways. And Rhode Island is saying, no, we're singling out tractor-trailers because they're the ones who do most of the damage.
So do they have an argument? I think I was reading that there's precedent before that the Commerce Clause has been kind of violated in the past, and it's held up, but I could be reading that wrong.
Oh, yeah. There have been many cases that have struck down state laws that were discriminating against interstate traffic, allowing state trucks to do things that out-of-state trucks couldn't do, like length, size, weight, that sort of thing. But there have also been cases that allow states to do things that seem to be pushing the boundaries. And it's very difficult to predict how this might come out because there are two members of the United States Supreme Court that have not been involved in cases that have dealt with this kind of issue. So we don't really know which way the court is likely to go at this time. But I think the Rhode Island statute is right on the edge of being unconstitutional or constitutional.
Well, what do we do here in this case? The governor believes that the state would be on solid ground if it went forward with its plan here. And what's your opinion of how risky a maneuver is that to go ahead and commit to this and then find yourself in court and then the costs attended to that? And so on?
It depends entirely on the facts of the case. There have been so many proposals put forward, and to the best of my knowledge, I spent the afternoon searching for what is the proposal at the moment, and I can't find one. I think they're still debating.
They are.
They are.
I think most of the Connecticut public are concerned about where the tolls are going to go, but I think what the courts are going to be concerned about is exactly how is the state going to phrase this? Who are they going to be taxing, and how are they going to justify it? And I just don't know the answer to that yet.
They are still crafting that legislation. They want it done by January, and that might have been also why they needed more time, too,
Yeah.
is that they're trying to, aside from the vote issue, button up their legislation to try to see if they can kind of skirt around what Rhode Island's dealing with, if that's possible.
Some of the things the court will be looking at is, well, the main thing they'll be looking at is the statute discriminatory? Statutes can discriminate on their face by saying out-of-state traffic pays the tolls. As I said before, that would be per se unconstitutional. But they can also find state laws to be discriminatory in effect, and that's what the truckers are arguing in Rhode Island, saying that, well, it may not say out-of-staters, but in effect, it's putting the burden on interstate traffic. And there's also a theory that says statutes or toll systems like this that are discriminatory in purpose also violate the Constitution. And there have been some statements made by Rhode Island politicians who were putting this program into effect that we don't want to pay for this. We would rather have out-of-staters pay for it. So if Connecticut doesn't get into the habit of saying things like that and can lay out a system that doesn't shift the burden too much to out-of-staters, they may be able to get by. But until we see the statute, we're not going to have any idea.
The impeachment situation. People are wondering what all this, some of the language confuses them and all that. For example, they talk about this is all based on hearsay and triple hearsay and quadruple hearsay and all of that. What does that mean?
Well, hearsay, or the rule against hearsay, is a rule in criminal trials in the United States that says certain statements that
But what does
somebody...
that have to do with this case? Criminal cases, they use that term, but in this case, did the framers intend for us to be worried about hearsay?
I don't think the framers were too concerned about the procedural and evidentiary rules we used. But the hearsay concern that some of the Republicans have been putting forward is that the whistleblower who came out and started this latest round didn't know any of this information firsthand. They said it's all hearsay and therefore it's not reliable. And there is probably something to that argument if all we knew is what the whistleblower said. But what the whistleblower did was open the way for other people to come forward. And now we've heard a great deal of evidence from people who do know firsthand what went on. And that's, generally speaking, much more reliable than hearsay evidence. And so I don't think it even matters that the whistleblower was only passing on hearsay. In fact, the whistleblower probably doesn't matter anymore at all because we now have spoken to people who really do know what's going on.
What do you think about the 2 articles of impeachment that the House crafted and put forward? Do you think that the way they worded it are the best argument for what they're trying to push forward?
I have some concern that the obstruction of Congress is not, at least at this point, a
And that's
valid
for not allowing people to come forward and talk and testify.
Yeah, exactly. Because, in fact, every president has the right to challenge Congress if Congress says, I want these documents or I want this person to testify. And virtually every president that has ever been ordered to turn over information or to allow people to testify has challenged it to some extent, sometimes by negotiating with Congress, sometimes by going to court. And in fact, Don McGahn has gone to court. And presumably everybody else that the House has tried to subpoena could also go to court. And that's part of our system. So it seems to me there's a very strong argument that the president is not unconstitutionally obstructing Congress until he is ignoring a court order to turn this information or to allow these people to testify. But he has gone further than other presidents. Other presidents have said, I'm not going to allow this to happen. President Trump has essentially said, we are not going to cooperate in any way whatsoever, and I will prevent anybody from testifying. And I can understand why the Democrats in Congress regard that as obstruction. But whether or not they should wait until it goes through the courts, I think, is a serious question.
All right. Well, how do you think it's going to turn out?
Predict the future, Bill.
I think it's going to pass the House, and I think it is not going to be convicted in the Senate.
That's fair.
That's my guess.
That's a pretty good guess, I think, based on it seems that's the way everybody's figuring
Thinking
it's going to go, but we may get surprises.
Oh yeah, things do happen. I just would be surprised.
All right, Bill Dunlap, thank you very much for coming here from Quinnipiac University School
Thanks
of
a
Law.
lot.
Appreciate it. The real story will continue right after this.